good morning, or afternoon. This is Jordan Walker with Seaver Walker Paget. I'm here to have our Ridgeline expansion webinar, where we're going to be talking about the pipeline. We're going to be talking about eminent domain, and we're going to be talking about what to do in this scenario when a utility company needs your land and how to respond appropriately. Probably going to be about 15 minutes today. So with that being said, we will just go ahead and jump in. Again, my name is Jordan Walker. I'm with Seaver Walker Paget. I'm an attorney. I'm an eminent domain attorney. I am the attorney at our firm that is working this project specifically, and I'm here to relay our experience in eminent domain and tell you, basically, give you some advice on what to do in the situation you find yourself in. So with that being said, a little bit more about our firm, so you understand that we're coming from a place of experience. We are an eminent domain only law firm. We are a landowner only eminent domain law firm. So a lot of folks that have done eminent domain work before usually don't do it as a matter of course. It's usually something they kind of do as a one-off. Not with us. This is the only area of law we practice. And not only do we only do eminent domain work, but we only work with landowners, meaning we've never worked with Enbridge, we've never worked with TDOT or any sort of DOT or municipality entity that can take land. We are strictly landowner only. And not only that, we have done hundreds of pipeline cases across the country. I've personally handled pipelines in Illinois, Indiana, Georgia. We've done work in North Carolina, Iowa, Tennessee, you name it. There's a lot of pipelines that are being built, especially presently, and really in the last 20 or so years, a lot of natural gas pipelines being built. So consequently, there's been a lot of landowners out there that are affected by eminent domain for utility projects, and consequently, we've helped quite a few folks out on their cases. So, as a result of this, we've learned quite a bit. We kind of understand how these cases work and how the utilities operate, how they interact with landowners, and most importantly, we understand how the eminent domain process works, and we're going to get into that in a bit. But today, our goal is to share our experience so that you can be informed and approach this situation with your property with as much information as possible. So real quick, talking about the project, this is an Enbridge pipeline. It's called the Ridgeline expansion. It's expansion of largely pre-existing pipeline. You can see a map there that I put on our presentation. And as you can see by the map, like I said, it goes through largely pre-existing lines, ending at the TVA Kingston plant there west of Knoxville. The project involves 117 miles of 30-inch pipeline and then an 8-mile 24-inch pipeline. 30 inches is, I would say, relatively big for natural gas pipelines. They can get as big as 48 and even bigger in some instances, but I would say 30 is about a medium to large size pipeline as far as these acquisitions are concerned. Because it is a natural gas pipeline, it is governed by the Federal Energy Regulatory Commission, FERC, as it's known as. And this pipeline is currently in the midst of the approval process through FERC. Every natural gas, interstate pipeline, and even intrastate natural gas pipelines require FERC approval, and it's going through that process as we speak. It's expected that they will get approval. That's not a guarantee, of course. People fight these projects quite a bit at the FERC level, but we are going to operate under the assumption that they do get this approval from FERC to build this pipeline. If they don't get this approval, then they can't build the pipeline. It's as simple as that. But largely, a lot of these, especially on pre-existing lines, they generally get approval as a matter of course, assuming they are following the law, of course. So that's the project. Let's talk about the eminent domain process. And this process will basically summarize 10,000-foot view of what you could go through in your acquisition. Most folks, well, all folks right now are at the pre-condemnation stage because they have not gotten approval yet, so they can't file condemnation lawsuits. Condemnation, I should say, is a substitute for eminent domain. And eminent domain is the ability of entities to acquire property basically through the court system and potentially against the landowner's desires. So most eminent domain is witnessed or seen or I guess utilized, exercised for road projects. TDOT, any sort of DOT government, county, city, they can utilize eminent domain to acquire land to build roads or schools or any sort of public use project, parks, railroads, etc. So that's the most common utilization of eminent domains through roads and those public works projects. But utilities also have eminent domain authority, assuming they get that authority from FERC. And that actually dates back to I believe the 20s when I believe it was the Natural Gas Act, or no, Natural Gas Act was later than that. But in any event, the Natural Gas Act granted this ability to get eminent domain through government approval and what's come to be known as FERC. So this is it's still eminent domain, but it's just exercised by a private company for what courts have determined is a public use, and that is pipelines, power lines, etc. So that's a little in the weeds, but nonetheless, we're not at eminent domain yet. We can't be at eminent domain yet because they don't have the ability to have it. But if they do get it, this is how the process looks. Prior to eminent domain, they have to issue an offer, and they already have done that on this project to quite a few landowners. Not necessarily everybody, but we have spoken to quite a few landowners who have received offers. So we are in that pre-condemnation phase. And once they issue that offer, what I tell folks is that's when our firm gets involved. That's when we can review the offer and let you know what our thoughts are on whether or not it's a good offer or not. But they will come through and they will make an offer, usually through a right-of-way agent. We'll talk about them here in a bit. And then there can be some level of negotiation at this point. But let's say negotiations break down, you can't reach a deal with the pipeline. What happens next? Well, assuming FERC has granted approval to this project, which we are expecting some sort of decision, I would imagine in early 2025, maybe late 2024, approval or rejection or what have you. And at that point, with that approval, and if you haven't reached a deal with Enbridge, they can file a condemnation lawsuit against you in federal, and they will likely do so in federal court. I say likely because they don't have to, but generally speaking, in these scenarios, pipelines prefer federal court to state court because they have this FERC authority and they are able to do it. And the federal process is a little more favorable to the pipelines than the state process. So it will be a federal lawsuit. You will be served a copy of that lawsuit. And ultimately, what that lawsuit becomes what the issue becomes is how much money you're entitled to, just compensation, in other words. You do have the ability to fight and try to stop the pipeline on your land at the condemnation lawsuit. However, I will say that is generally a pretty difficult fight to mount. You have to usually have a very specific set of facts that supports that argument, and those specific set of facts don't usually exist. It is a very difficult climb at that point. We have done it before, and if you're interested in something like that, we can talk about that. But I will say that largely the eminent domain case and the trial or the litigation itself is over the amount of money you're owed and not necessarily whether they can take the land. So it is important to note, and in federal court, you do not have a guarantee of a jury trial. You do have the guarantee at the state level, but if they use federal court, then you do not have the guarantee of it. It will likely, your trial, so to speak, if you get to that point, will be held in front of either a judge or a set of commissioners. It is possible to get a jury trial, but you do have no guarantee. So this is the eminent domain process. This is beginning to end. And I want to say this is that most folks in these situations do not reach eminent domain. Most cases, as a matter of fact, most of these types of cases settle pre-suit without getting that far. They certainly can, and we've been a part of that before. But most of our cases with pipelines usually resolve pre-suit. But ultimately, if the pipeline doesn't work with you and pay you what you're entitled to, then you might have no choice. If they're not willing to negotiate and come to an amount of money that's fair to you and that properly compensates you, then you might have no choice but to go to eminent domain to ensure you get that right amount of money. So I want to focus on the negotiation stage of the process because we talked, I talked about the eminent domain process. I want to talk about the negotiation with the right-of-way agents. I've dealt with right-of-way agents quite a bit. I deal with them pretty much every day. We've worked, like I said, we've worked on quite a few projects across the country, and we've seen a lot of recurring things that happen. I call them tricks. You can call them negotiation tactics if you'd like. I've seen, these are examples of situations I've seen from right-of-way agents. And I think the bottom line to remember when you're dealing with right-of-way agents is that they do not work for you. They work for a company who is being paid by Enbridge, meaning, your interests are not at heart, or at their heart. Their interest is getting your property for as cheap as possible and as quickly as possible. So I tell folks to just remember that when you're dealing with these folks, that they can say a lot, but ultimately, the only thing that matters is what the paperwork says and what the documents say. And a lot of times, right-of-way agents, landmen as they're called, will come out and make a lot of promises and verbal promises, and then kind of kind of back out of those promises, or they no longer exist when it's time to sign. So it's just important to remember, who's paying who in this scenario, and what the financial motive is of all the parties, including right-of-way agents. And these are just some things that we've seen right-of-way agents employ to try to get these easements signed. They make the impression that they're offering more than fair market value. But who's determining fair market value in that scenario? Is it them? And 150% of a terrible valuation is still not a fair amount of money. Bonus payments, they're doing you a favor. If you sign now, we'll give you another $500, another $1,000, whatever. If it's creating the impression that they're doing you a favor, they're looking out for you so that you avoid maybe the larger issues. Not appropriately paying timber damages or crop damages. I know that this land is largely timber recreation ground, so it's important you get paid properly for the trees that they're tearing down. And sometimes they'll offer them, but not nearly enough. Again, to give you the impression that they're doing you a favor by paying for something that they're going to themselves take down, something that they would owe you anyway. I would say that, they like to focus on, sometimes play a shell game where they want you to focus on the low dollar issues while ignoring the high dollar issues. Example of this would be, quibbling over the fair market value of the land, for example, whereas you're ignoring, what the impact of the construction is going to have on this property, or the impact on the value of the property because of the addition of the pipeline to the property's value. And by quibbling over low dollar amounts, like, if it's a 3-acre acquisition and they offered $10,000 an acre, and you're quibbling over $12,000 an acre, ultimately that's a $6,000 difference in the easement acquisition. And that's a conversation they would love to have with you, because $6,000 is not much. It's a low dollar amount in the grand scheme of things. But if you're focusing on that, for example, and not talking about the impact on the overall value of the property, which, if you have a 20-acre piece of property, and its value is reduced by 20% because of this pipeline, then you're talking about much higher dollar figures. And those are the conversations you should be having, and not having the low dollar discussions. It's important to remember that you have leverage as a landowner, your ability to say no, and right now, which you do have the ability to say no. You don't have to accept the first offer that's issued by pipeline. You don't have to accept the second offer. You have the ability to say no, and the ability to say no gives you leverage. I've seen offers that are, again, they're written down on a piece of paper, and they take the piece of paper with them. I've seen verbal offers issued that don't materialize when the time comes to sign the paperwork. A verbal contract is as good as the paper it's written on. These verbal promises mean nothing. Lowering and raising offers, kind of keeping the landowner on tilt, not sure what's going on, and is it going to go up, is it going to go down? These are all things that, and there's many more that I'm missing. These are just kind of tactics, again, that we've seen from right-of-way negotiation, from right-of-way agents. Ultimately, if you're not sure if it's a good deal, just give me a call, shoot me a text, shoot me an email, send me your offer. I will look at it for free, and I'll give you my thoughts, and you can decide what you want to do. Here's what I tell people to do when you receive an offer from the pipeline company, from the right-of-way agent. It's important to keep everything written. I will say that I would avoid in-person conversations. I would avoid phone calls, anything that doesn't have a record attached to it, in writing. Email is the best way to do it. Text is also a good way to do it. But I tell landlords, insist the right-of-way agent communicate via email only, so everything's on the record. Then once you receive the offer, you can tell the agent via email, thank you, I will review this and get back to you in a week. I say this because a week, they're not going to do anything in a week. No one's going to be put off by you telling them that you need a week to review this to get back to you. So you're not in danger of losing something. You're giving yourself enough time, due diligence to review it. Most right-of-way agents will respect this request if you give it to them, because then it also informs them or tells them that you're not putting them off and you do intend to engage. Now you might be doing it through counsel, but you do intend to engage, and but it'll be a week to allow you to get your bearings. I think this is a good approach for most landowners. It allows everybody to keep an even keel during negotiations while you figure out what you want to do. So that I would send that email, and then I would immediately contact an attorney for review of the offer. You can then, if they send the offer via email, then you can very easily forward that offer to an attorney for their review. That's another good reason why to do this. And then once you get that offer, contact an attorney. Again, I will review these offers for free. You don't even have to tell me you're going to send it. Just send me an offer, and I should be able to understand it and give you my thoughts. Again, avoid in-person discussions, avoid in-person negotiations. They are nothing good can come for the landowner from an in-person verbal discussion with the right-of-way agent. Everything should be on the record, so to speak. So that's what you should do. Here's what you should not do. Don't engage in negotiations or discuss value or anything about the property before contacting the attorney. And that seems counterintuitive, excuse me. When somebody comes in and they make an offer on your property and you're interested in selling, your initial response, of course, is to throw a number out or start negotiating. But the reality is that you might be undershooting your amount of money. You don't necessarily know what you could potentially get for this pipeline acquisition. We have done these acquisitions, of course, in many different states, and we understand what pipelines can generally do from a compensation package perspective. And so, this is why we tell people to not necessarily engage in these negotiations, because you might double a terrible offer. And you might think that you got a great deal and you did a great job, but what I tell people is doubling a terrible offer doesn't necessarily make it a good offer. It might just make it a bad offer or a less terrible offer. So that's why I tell people generally, avoid getting in these discussions before talking to somebody who can give their thoughts, give their proper evaluation. Don't go out and get an appraisal. I'll say that, with force. A lot of people, again, think that they should go out, get an appraisal because they have an appraisal or they said they appraised the property, so we should too. I would not do that. They're very expensive and a lot of times not necessary. In our view, appraisals, these types of expert costs aren't necessary unless you get to eminent domain. You don't want to spend money on something you don't need. And so I generally advise against it. Do not meet in person. We already talked about that. Do not take their promises at face value. We talked about that. Again, do not assume their interests. They have your interests at heart, because remember who pays their bills and who pays their salary. Then finally, do not make a rush decision, but also don't ignore it altogether. I've seen a lot of folks, they do one or the other. They rush into accept the offer or they ignore it altogether. They put it on the back burner and nothing happens for months, and all of a sudden they're in eminent domain. They don't know what happened because they didn't do anything. I don't advise just ignoring it. I think the easiest way is just, once you get the offer, send it to an attorney, get a plan together on what you want to do, and either let the attorney handle it or do it yourself. I generally wouldn't advise doing it yourself, but that of course is your option. Now, I want to talk about what exactly they want from you and what they're trying to buy. What they want is an easement. Of course, for a large portion of this line, there's already pre-existing easements that exist, so you might have some familiarity with what an easement is. But in case you don't, an easement is essentially a deed, but instead of selling the entirety of the property, which deeds normally do, at least most people are familiar with a traditional deed that sells the entirety of the property. It's a deed only to usually a certain area of the property, And then not only that, it's not for the entirety of the land, but just the right to do something on that area of the land. And one of the questions I get most of the time is, will the pipeline be allowed to do this or that or this? Do they have to do this? Do they need to do that? Et cetera, and so forth. And my answer to that question and its variations is the same thing every time. Same answer every time. That is, it all depends on what that easement says. And remember, what is told to you is not always what the easement says. Ultimately, the verbal promises made to you by right-of-way agents during your discussions mean nothing to the easement. They don't show up on, if they don't show up on the easement. If they don't show up on the easement, there's nothing, 10 years from now, when that pipeline's been in the ground for 9 years, and they're coming in willy-nilly and messing up your trees further to maintain the pipeline, to continue, to do whatever they need to do to keep it operational, and they're coming in at all times and days to do this maintenance. And you are sitting there saying, well, the right-of-way agent told me that they notify me before they'd come onto my land, or they told me that they wouldn't come in anymore down the road, or they would only use the roads to access the pipeline, or only use the easement to access the pipeline. The problem is that those verbal promises mean nothing, especially 10-year-old ones. So ultimately, what is the most important document of your case is the easement. And what we're seeing, especially on cases on projects where there's pre-existing easements, a lot of landowners realize the dangers of bad easements, because a lot of old easements, 50s, 60s, 40s, 30s, et cetera, they're usually very poorly drafted. And because they are easements, they are forever. They last forever. They are always with the property. They stick to it unless it's extinguished by the pipeline company. So you can see now how bad easements can come back to bite landowners in the butt. And the issue again is that it's not only about how it affects you and your land; it's how it affects your land as it is inherited by your kids or your grandkids, or whoever ends up getting the property. Ultimately they're going to inherit, or they're going to take it subject to this pipeline and whatever this easement says. So it's imperative that this document is drafted carefully and in your favor to prevent things down the line from happening that you don't want to happen. Some issues we've seen on poorly drafted easements, unfettered access, and this is I've seen on this easement, on this project specifically. Unfettered access. They can access the easement from anywhere they want, whenever they want. I've seen issued no clause for future damages and crop losses, meaning if they come in 6 years from now and they knock down a bunch more trees to maintain the pipeline, they won't have to pay anything further to the landowner. No clause for proper ground restoration. It's very important to ensure that this construction is done with at least some care for the land itself. And a lot of times they'll just do what they want if they don't have any requirement to do otherwise. So it's important that they, implement proper construction techniques, especially for the ground, to make sure the ground is still supportable in the after, and it's not, there isn't going to be severe erosion or anything like that, and the proper care is put into the construction. Liability to the landowner for issues. I've seen that where the pipeline, if the pipeline, something bad happens to the pipeline, the landowner could be liable. The right to build more pipelines. I've seen this a lot. And as a matter of fact, on this easement, I've seen it does include the ability to add much more than just one pipeline. And that is a fairly common clause that pipeline utilities like to sneak into easements, where they'll sneak in all sorts of stuff that they tell you, we're only building one pipeline. This is it. It's only going to go right there. Don't worry about it. But if you read the easement, it says it can put 1, 2, 3, 4, as many as they want. And that becomes, in effect, that becomes an extremely valuable asset to the utility, because then they can sublease their rights under that easement to another utility company and not pay you a dime, because you already gave them the right to sublease it. So it's just, I'm throwing a lot at you, but it's just important to remember that these easements need to be crafted very carefully, and they need to have very strict protections for you in the future and during construction to protect your property. And of course, as I said previously, easements are forever. Once it's signed, once it's recorded, that's it. It's always going to be on the property. So it demands your attention that that document is drafted accordingly. And folks, I'm almost to the end, and then we'll take questions. I will say that, we talked about the easement. Here is the compensation portion of it. A complete compensation package, and this is the money for the easement, should include, you should have a proper price per acre. You should have a proper payment for crop or timber damages. And these would be prospective. You get it up front as opposed to as they happen, and then also get it as they happen if there are any damages that aren't foreseen by the acquisition. Either payment for anticipated soil and ground damages or a clause that demands remediation of the land, proper consideration of all potential damages that could be realized during construction and later. Residual damage, I already touched on that. How does the introduction of this pipeline affect the overall value of the property? Usually it's a pretty negative impact, and you deserve compensation for that. And these are all in addition to any bonus payments that were issued by Enbridge Pipeline or a utility. So that would be a proper and likely comprehensive compensation package. Obviously, landowners have individual issues on their property that may come up as well. And if they do exist, you can just tack them onto this list. And finally, I want to talk a little bit about hiring an attorney. I can only speak for our firm specifically, and how you can afford an attorney to handle your case against Enbridge. Our firm operates on a contingency fee basis, meaning if you're offered $10,000 and we get you $50,000, these are examples only. This is not a guarantee or anything. These just provide an example of how our fee would work in this scenario. So in this scenario, if you were offered 10, we got you 50. That's a $40,000 difference. We get a third of the difference that we added to the case. You get the rest. We do it this way because it allows landowners to hire us without coming out of pocket, and we understand a lot of folks don't want to do that. In order to hire me as an attorney, it's as simple as signing a contract, and that's it. You don't send me money. You don't need a retainer. We don't bill. All these things that maybe landowners think about when they think about attorneys, we don't generally do. We only get paid if we get you more money, and our fee comes out of that extra that we add to the case. And we do it this way, besides the landowners not wanting to pay retainers, but more so because it provides peace of mind to landowners to understand that in this agreement, this arrangement, we are on the same side. We are both financially motivated to get as much money as possible because we become partners in this case, and we have an interest as well that we want to maximize too. So you can be sure that we're on your side, and we're going to do as best as possible for you, because we're also working for our benefit as well. So with that being said, this is my final slide, and we'll open up for questions if there are any. Moving forward, as soon as you get an offer, that is the time to hire an attorney. If you haven't received an offer, I think what I tell people is to begin vetting your options, talking to folks, and considering planning your strategy when you do get the offer. Identify your priorities and goals of what you want out of this scenario, what you want to happen. But as soon as you get that offer, that time to hire is then. And again, if you have an offer, I'm happy to review it for free. You can text it, you can fax it, you can email it to all of those. The phone numbers and the emails they're up on the screen right there, jordan@landownerattorneys.com. And you can text it to 470-869-1383. And before I open to questions, I do want to bring up one point. I have a bullet point about strength in numbers and being able to get a group together. As it turns out, we already have kind of a group going on this. We already represent several landowners on this project specifically. We've already begun discussions with their right-of-way people, looking at the easement, things like that. So we have a group. And if you're interested in joining that group, I think we'd be more than happy to have you if your case is one that we would take. I want to stress, though, even though we have a group going, this is a scenario where your resolution is specifically affected by other landowners. You still have your own case with your own requirements, your own unique facets that need consideration. So just because we have a large group, it doesn't mean that your parcel is being negotiated as a whole, and you're not going to have the issues addressed that you might have. It's not a class action. Everybody's case is different. Everybody has different aspects and issues that need to be addressed. So just something to keep in mind. We already have something going, so if you want to be a part of it, I think we'd be happy to have you. So with that being said, I am going to go ahead and open it up for questions if there are any. Hey, it doesn't look like there are any questions. Thank you for stopping by, and let me know if you have any questions.